past 2 years has seen the Supreme Court of the United States fundamentally reshape the government's ability to regulate greenhouse gas emissions. I'm primarily talking about rulings in 3 cases: West Virginia versus EPA in 2022, and then 2 cases called Loper Bright and Corner Post in 2024. Loper Bright got a lot of attention because it is the case that got rid of what's called Chevron deference. Chevron deference was a precedent that was in place for a number of decades. It basically said that when legislation or a particular statute has not been explicit about exactly how a law should be implemented by an agency, it's up to that agency to decide how to implement the law. The idea being that laws are often quite vague. It's up to regulatory agencies to implement those laws based on what their experts are telling them. That is gone now, which means prepare to see a lot of lawsuits about regulations, particularly environmental regulations. The Corner Post ruling came out during the same Supreme Court session and got almost no coverage, but is equally problematic when it comes to environmental and climate policy. That case got rid of the statute of limitations on legal challenges to previously passed legislation. So if you think about the most recent 10 years or so, an administration comes in, they pass a new power plant rule, it gets challenged, that makes its way through the courts. We have not seen, for example, a challenge to a rule that came about in the Clinton administration because there was a statute of limitations on that sort of litigation. Now that's gone. So just think about what that might mean if the Koch brothers, for example, continue to fire up their litigation machine and start filing suits challenging all of the past 20 years worth of environmental regulations. That is what we are in for in the years ahead. Now, before West Virginia came along and said that because the Clean Air Act didn't explicitly lay out climate policy, the EPA cannot use it to regulate greenhouse gas emissions, another case, Massachusetts versus EPA, ruled that in 1970, when the Clean Air Act was passed, climate science was, quote, in its infancy. And they inferred from that Congress could not possibly have meant for that act to be used to regulate anything related to climate change. In a new study in Ecology Quarterly, Naomi Oreskes and a handful of other researchers with her at Harvard University decided to look into whether that is even true, this idea that climate science was in its infancy in 1970. What they found was that climate science really was not in its infancy in 1970. Then, in fact, there was not only quite a bit of scientific knowledge about climate change, both at the oil companies themselves, as we know, and also in the government, but that even in a lot of popular culture, climate change as a thing that was happening and that was understood to be caused by fossil fuel combustion was pretty commonly known. They found all of these really incredible examples of late night talk shows talking about it, beat poets talking about it, movies, TV shows, all kinds of spots where it seemed unlikely that people would be talking about this issue if it was not more widely known. That research calls into question a lot of the assumptions that some of these recent rulings have been based on, which makes things a little more interesting. I talked to Oreskes about her research, what was new and surprising to her, how this history shapes how we understand the whole history of climate science in general. And I also called up Patrick Parenteau at Vermont Law School to ask about how this new research might play into the cases we're expecting to see in the next couple of years. That's all coming up after this quick break. I'm Amy Westervelt, and this is Drilled.
What does every USAA member have in common? Family. We're one big family who supports the military community and their eligible families. And if you, your parent, or spouse served, you could join our family and save big on auto insurance. Visit USAA.com/join today to check your eligibility. Membership eligibility and product restrictions apply and are subject to change. USAA means United Services Automobile Association and its affiliates, San Antonio, Texas.
I wanted to just ask you first, what prompted you to start looking into this? Did you start doing the research after West Virginia versus EPA, or was there another?
Well, this paper has been super long in coming, and it's actually taken a long time, partly because it turned out to be a much, much bigger project than we expected, and partly because we all had other day jobs. So this was something being actually as a second project or a third project. So the short answer is actually I've been interested in this question really ever since Mass versus EPA, when the Supreme Court said that in 1970, climate science was in its infancy and implied, therefore, that there was no way Congress could have really understood the problem enough for them to intend for the Clean Air Act to apply to CO2 and greenhouse gases.
Yes.
So, as a historian of science who was working on the history of climate science, that statement that climate science was in its infancy, I knew it was wrong. I just knew that was false because already by that time I had been working probably about 5 years already on the history of climate science. And I knew that already in the 1950s, in the 50s, we see the beginning of what becomes a sustained, half a century of important scientific work on CO2, the greenhouse effect and its potential implications. But what I didn't know was how much had that been communicated to government? And you might recall in Emergence of Doubt, we cite the 1965 PSAC report on the environment that has a whole appendix about climate change. And we know by the time we wrote Emergence of Doubt, which was in 2010, we knew that at least President Johnson was aware of it. We know that that report landed on his desk, and we know that he mentions CO2 and climate in his special message to Congress that year. So I knew that there was a pretty significant scientific conversation already taking place by 1965. I knew that Dave Keeling by 65 had already concluded that he had enough data to say, yeah, this is going to be a big deal. And we knew that it had reached the executive branch through PSAC. But what we didn't know at that time was how broad was the conversation. And did Congress know about this? Because obviously we have separation of powers in the U.S. government. So it's plausible that the executive branch might know stuff that they did not communicate clearly to the legislative branch. So that was something that I had been interested in for a long time. And then at some point, I can't remember exactly when this was, but it was shortly after I moved to Harvard. So this would have been 2013, 14, 15, something like that. Jody Freeman called me kind of asking the same question. What did we know about what was known about this issue when the Clean Air Act was written? Because the preamble to the Clean Air Act includes the words weather and climate. So on any straightforward, non-tortured reading of the statute, it obviously relates to weather and climate because the words are in the statute. And when the statute talks about impacts on weather and climate are one of the things they say. Right. So it seemed pretty obvious. But the other side had argued in a couple of amicus briefs, when they use the word climate, they didn't really mean it the way we mean it today to mean global climate change. They were just talking about the climate of California or the climate of North Carolina. They were thinking about local effects on climate. Well, so we thought, we could answer that question. And it is true that sometimes words can be used in different ways. And it is true that the word climate can refer to local or global climate. Mm-hmm. So I hired Colleen, my graduate student, Colleen Rainier Christensen, who's the second author on the paper, to just do a little bit of digging. And very quickly, the project grew, and we discovered this really astonishingly broad and deep conversation among scientists and among Congress and members of Congress about this issue, about global climate change related to greenhouse gases in the atmosphere. And so we started working on this, raised a little money, paid for Colleen to be a research assistant. And as it grew and we found more relevant things, then we recruited Hannah Conway to join the project. And then West Virginia happened, and this so-called major questions doctrine. And one of the things that the court said in that case, as you know, was to introduce the standard of the vast economic and political significance. Mm-hmm. And to say that if something is of vast economic and political significance, that it raises the bar for agency regulation, and that therefore the statute has to be absolutely explicit before an agency could make choices. Now, we could argue about the justification or wisdom of that claim, but I'm not a legal expert, so I wouldn't want to get into that. But what we did know when that decision came out was that we actually had people in the 1960s talking about the potentially vast economic and political significance of doing something about CO2. And we even had conferences where people from Ford Motor Company had been at the conference discussing these issues. There was a report on electric cars by the Department of Transportation that specifically talks about how CO2 might force us to convert the entire automobile fleet to electric. So that kind of lit a fire on us and said, okay, we've been working on this project for years, kind of back burner. We need to put this in the front burner and we need to get this written. And so that's the story about the paper and why it's now coming out. So it absolutely is relevant to West Virginia, but it was not motivated originally by West Virginia.
That's so interesting. I know you're not a legal scholar, and I'm going to try not to ask you legal strategy questions, but I am curious if you've heard from folks in the legal realm about how having this information might help with the next. I mean, like, I know the EPA's most recent power plant guidelines have already been challenged, and I imagine that they're going to fall into this thicket of major questions doctrine and now post-Chevron deference stuff too.
Yeah, well, I'm sort of careful about that. I don't spend a lot of time talking to lawyers who are actively engaged in these kinds of cases in advance of me doing my research, because I really want us to look at the evidence as objectively as possible and let the chips fall. And then it's up to lawyers and judges to decide the consequences and implications. So, I mean, this isn't part of a legal strategy. And although I'm sure that some of our opponents will probably claim that, it's not part of a legal strategy. It wasn't written to support any kind of particular legal approach or much less any particular case. But obviously, we think it has implications. We wouldn't have done the work if we didn't think it mattered. And so let me read you something that actually Ashton wrote in response to a query from a different journalist about this. So Ashton McFarland, a JD PhD student who's just finished his JD at Harvard Law School and now is working with me doing a PhD. And we recruited to participate in this party because we felt like we did want a little bit more legal insight. And he's studied with Jody Freeman and Richard Lazarus and all the big name environmental law professors at Harvard. So here's what he wrote. The major questions doctrine requires a clear statement from Congress to authorize regulatory action of vast economic and political significance. The doctrine reflects an assumption that Congress would be exceptionally clear when granting an agency highly significant regulatory power. How do we determine what counts as a, quote, major question and a, quote, clear statement? The Supreme Court has implied that the inquiry depends on both context and history, yet the court missed large swaths of relevant history about climate change, which we present in this article. This history is important not only to the wholesale question of whether the Clean Air Act covers greenhouse gases, which we think it clearly does, and our paper then supports that, but also to the retail question of whether any new climate regulation is sufficiently well authorized. And then he goes on to say, the court has not said precisely how history informs the major question analysis, nor what types of historical material matter most. Our key point is there is a whole lot of history that the court overlooked, and it should not overlook that history in future climate cases. And I guess what I would add to that is that so much of what the court claimed was about this issue of the clear statement, and they've repeatedly implied, both in Mass versus EPA and in West Virginia, sort of continued to imply this idea that there's no way that Congress could really have intended this to apply to CO2, A, because they didn't really know, and B, because they hadn't anticipated the vast economic significance. And we think this paper shows that both of those implications are wrong.
I called up Patrick Parenteau at Vermont Law School to ask about how this new research might come into play in some of the cases we expect to see in the months and years ahead.
The bottom line is, what we're now talking about is the margin. We know we're going to lose almost all of the cases that make it to the Supreme Court docket. It's now a question of, can you, in some cases, work the margins? And that means either Roberts or Barrett, maybe even sometimes Kavanaugh, almost never Gorsuch or Alito or Thomas. If you're alert as an advocate, as a lawyer arguing these cases, there's got to be a way to cobble together votes if you can convince them that the text of the statute ought to be interpreted in a certain way that they call the best reading. That's where we've come to. What's the best reading of the text of the statute, since we're all textualists now, as Justice Kagan has famously said. And so, the best reading does, to some extent, turn on what was on Congress's mind, what did they intend, what can we infer from the type of words and language they used, was their intent. And we know that both of the rules, I should say, that are now in litigation, the car rules, the tailpipe rules, and the power plant rules, we know the odds are one or both of them are going to wind up on the Supreme Court's docket. But the point is, the combination of all these decisions, West Virginia, Loper Bright overruling Chevron, Corner Post knocking out the 6-year statute of limitations, meaning any of the rules on the books is fair game. We haven't begun to see the avalanche of lawsuits that we're going to see with Pacific Legal Foundation and Koch brothers money. Man, oh man. So you have to look at that whole suite that we've seen. And of course, we've got more coming. When you look at that, the agency lawyers and the staff, technical staff, they've got to be thinking, man, can we get 5 votes? Can we get 5 votes?
Right.
And you just you do a head count and you figure out, who can we get to support this interpretation? They're zeroing in on already what's sometimes called antecedent interpretations of a statute. In this case, we're talking Clean Air Act. So for the car rules and the power plant rules, they're going back to the 1970 Act and tracing forward and the history and how they've been interpreted before, so that the interpretation of today is not new. So now we'll find out. Now we will really find out if EPA's attempts to justify these 2 rules. We'll find out whether it's possible for EPA to get the 5 votes they need to uphold these 2 rules, or whether Morrissey and company, Patrick Morrissey, West Virginia company, are right that no matter what EPA tries to do to address climate, they're going to lose, because everything they do is a major question. They don't get any deference. The best reading of the statute is not what EPA says it is, etc. So in that sense, this really robust, sophisticated analysis of the history of the Clean Air Act has got to make a difference.
Okay, there are a number of things in here that are really interesting and that had not been published before and that people did not know about in terms of this history. I imagine there were things that were surprising to you too. What were some of the most surprising discoveries in terms of when people were talking about what?
Well, there were a bunch of things. The biggest surprise actually was Sports Illustrated and the Weekly Reader, and just to see the way that this had permeated into popular culture and popular conversation very, very early on. And I think we all fell in love with the Allen Ginsberg piece. Here's this beat poet, right? He's a poet, not a scientist. He's on the Merv Griffith Show, which is one of the most popular talk shows on television in those days. I mean, Merv Griffith was the Oprah of the 1960s. And he's talking about climate change. He's talking about the ice caps melting, and he's linking it to cars. He says pollution from automobiles can melt the ice cap and, flood the coastal cities of the world. I mean, that is 100% global climate change as we understand it today. And Allen Ginsberg has got it in a nutshell in the 1960s, and he's talking about it on primetime. And then the other piece I really loved was, and Ashton found this. So then this angry constituent in Washington state writes to his senator, Henry Jackson. And Henry Jackson was one of the most famous, powerful senators of that time, someone whose name was well known to me that I remember from my own childhood. I mean, I remember we didn't like Scoop Jackson because he was very pro-Vietnam War. So this is a very famous name. I mean, this whole project, all these names that I already knew kept popping up. These were not minor people. So Scoop Jackson is one of the most powerful people in the U.S. Congress at the time. The constituent writes to him complaining, asking him to do something about it. And Jackson reads the letter. And instead of just throwing it in the bin or thinking it's a hoax or whatever, or the guy's crazy, he writes a letter to the president's science advisor, Lee DuBridge. This is the advisor to Richard Nixon, so a Republican president. And he says to DuBridge, well, what about this? Is there any truth in this? And Lee DuBridge writes back a multi-page letter in which he explains very carefully and patiently, he explains to Henry Jackson that, yes, actually, this is a real thing. And then a few months later, he goes on Meet the Press, again, mainstream American television, to talk about the issue. And he even says we might need to have a carbon tax. And this is in I forget if it was 69 or 70, but right before the passage of the Clean Air Act. So here you have a powerful senator, the science advisor to a Republican president, just talking openly and honestly about this issue and not being dismissive, not thinking it's a hoax, but actually taking it seriously and trying to learn. And I just thought that was kind of beautiful.
It's so interesting. I also thought the Frank Capra movie.
Frank Capra movie was great too. And, Mr. Science. I know that was brilliant too. And again, Frank Capra, super famous name from the history of film, right? So again, I feel like for me, the biggest surprise overall is I knew scientists were talking about this, but as you know, a lot of scientific conversations can be very in the weeds. Scientists can really live in their own science bubble. And so what I didn't know was how broadly this information had percolated in the 1960s. That, I guess, was the biggest surprise. And of course, that reinforces our claim that Congress was aware of this. They were talking about it. They knew about it. They heard testimony about it. They were getting information from leading scientists like the president's science advisor, like the head of NCAR, Gordon MacDonald, who's serving on CEQ at that time. Important leading scientists are talking to important leading members of Congress. And that's crucial then in the context of the major questions doctrine for understanding what Congress knew about this issue and therefore what they could have intended when they wrote this law.
In any of the stuff that you found, did you get any sense of why they steered clear of being more specific in the law?
Yeah, I would think we do know the answer to that. And our group had a lot of discussions about this. I mean, part of this whole thing has to do with whether or not they understood CO2 to be a pollutant, and therefore whether they intended these discussions about pollution to include CO2. The answer to that question is absolutely yes. And that was one of the other big surprises. It was astonishing to us how many conferences on air pollution in the 1960s discussed CO2 and how many reports that are written on air pollution mention CO2 as a pollutant. So there's absolutely no question that they understand that CO2 is a pollutant. But there's two things that we think happened. The first is that there's a very clear conversation about what kind of a pollutant is it. So while they recognize that it's definitely a pollutant, they also say, and this is something that still comes up even today, that it's a different kind of pollutant. And so the way we've been thinking about it now is taking a parallel from public health to distinguish between acute and chronic threats or acute and chronic disease. So they recognize that CO2 is a pollutant, but they say it's a different kind of pollutant than the sort of things that are leading to smog in Los Angeles or New York or other urban areas. And the immediate attention of the moment is on the acute pollutants because they are literally killing people, right? People are going to the emergency room in Los Angeles on bad air days. And so understandably, the primary focus of discussion is on these acute pollutants, which then lead the EPA to create the National Ambient Air Quality Standards for things like NOx, SMOX, arsenic, mercury, stuff like that. But they also understand that these other things are pollutants too, and that they need to be dealt with, but maybe not immediately. And so we come across various reports where they say things like in the fullness of time. And so we had a long discussion in our group about, well, what do they mean by in due course or in the fullness of time? And that's actually a really hard question to answer. But here's how I've been thinking about it. The team thinks that, like Hannah Conway, I remember asking this to her specifically. She said, well, she thinks that they thought it meant like within the decade that we were going to deal with these acute threats first, but then we would get to these other chronic threats. And I think that the scientific community was part of that because the scientists themselves recognized that even though they were confident that CO2, if it was left unabated, would lead to climate change, or would almost certainly, or would probably, you can put in whatever caveat you want. But there were a lot of details that in the 1960s were not well understood. For example, you see discussions about ocean heat uptake. You see this about the biosphere. So these were big scientific questions which scientists themselves understood needed to be addressed. So in the 1970s, that's when we see the growth of climate modeling. That's when Suki Manabe begins to build his first climate models at the Geophysical Fluid Dynamics, the work from which he finally won a Nobel Prize a couple of years ago. So there's this sense in the scientific community that, oh yeah, that makes sense. We've got more work to do. And so I think that everyone involved in this conversation, both the scientists and the legislatures, understood that CO2 was a threat, understood that it was a serious threat, understood that it would have vast economic and political consequences. Either way, whether we regulated it or we didn't regulate it, it would have vast consequences. But they thought, we have a little time to work this out. And what they meant by a little time was a decade or maybe two. And that actually fits with the larger history that I've written about. If you think about it, so in the 1970s, we begin to see the first global conferences on climate change. We see the National Academy issues a couple of reports, the famous Charney report. And then in the 80s, we get the creation of the IPCC. And in 1992, the UN Framework Convention on Climate Change. So in fact, the sorting of the science and the move to regulate CO2 do happen within the 1 to 2 decade framework that people anticipated. But the giant but in this story, the giant spanner in the works, is that in the late 80s, as the science starts to come together, that's when the fossil fuel industry begins to try to fight it.
Yeah. One thing I want to ask you about is that, we've started hearing from the fossil fuel companies in the last 10 years, maybe a little bit less. This whole idea of everybody knew, so you can't just hold us accountable, right? I'm sure that they will find ways to use the stuff in here to bolster that argument. So I'm curious what you think about that.
Well, that's exactly the same argument that the tobacco industry used. They are once again using the tobacco playbook. And there's 2 important answers to that. Yes, we did know, but then we got confused about this because of what the fossil fuel industry did. They worked actively to undermine our knowledge and understanding. And we may do a follow-up paper to answer exactly that question. Why was all this understanding lost? Why did so many Americans, say by the 80s and 90s, and even into the 2000s, think we didn't really know, that there was no scientific consensus? All that stuff I've worked on in the past.
Yeah.
The answer to that is fossil fuel industry malfeasance. So they are responsible for the fact that we lost this knowledge that we actually used to have. So that's the first part. And then second part is that I'm not a legal scholar, but the law is very clear. If you produce a product that kills people, the fact that some people knew that it may kill people doesn't get you off the hook, right? Corporations have legal responsibilities. Just because someone may or may not have known about something doesn't absolve you from legal and moral responsibility for the consequences of your actions.
Yeah. That's it for this time. We'll be back soon with another episode. Don't forget to check out the print stories on our website at drilled.media and with various co-publishing partners, including Rolling Stone and Vox. This episode was mixed and mastered by Peter Duff. Our theme music is Bird in the Hand by Forknown. Our artwork is by Matthew Fleming. You can also check us out on Twitter at We Are Drilled and everywhere else on social media at Drilled Media. You can sign up for our newsletter on our website as well. That comes out once a week and gives an overview of an important story that's happening in the climate universe, plus suggestions for the week's 5 must-read climate stories. It's never more than a 10-minute read, and people tell us it helps them keep up to date on all things climate.